What's up, everybody? Unplanned live as soon as new Kohberger documents drop because these are a little confusing, and people have questions, and we're going to read through it, and I'll explain why some of it matters more than other parts of this affidavit, what the purpose of the affidavit is, and we're going to try to focus on that as we read it so we can understand why it was filed and why all of this information is in there, not necessarily to prove the truth of what is explained in the affidavit or even that this is the right way to do it or the right way to look at it. But the purpose of affidavits like this in these situations, I think, is really important to think about as we read it. So I'm going to be out all day tomorrow, taking my kids somewhere fun, but it's a surprise to them. So I don't want to see it in case or say it in case they can hear me. Right before school starts, taking the day off. So no lives, although I do have a pre-recorded Alexi Treviso video that's going to drop tomorrow. But hit that like button if you haven't already. Subscribe to our page, hit the reminder bell just in case, hey, 2 lives in one day happen you don't want to miss out on. So why was this affidavit filed that we're about to read from this DNA expert hired by the defense? Well, for some reason, the document loading is not showing the first page, which is in support of the defendant's, I think it's third motion to compel, but one of the defendant's motion to compel dealing with this DNA evidence. That's the state keeps saying they don't need it. Doesn't tell them anything. They're not going to pull anything from it. That's going to be the defense's evidence. The state's already telling the court, we're not going to use any of this as evidence. Doesn't fall with any of the rules. It's not reasonably calculated to lead to discoverable material. Therefore, they shouldn't even get it. So with that in mind, thinking about the fact that the defense says they need this DNA information. They've been trying to tell the court different ways. They also had to do it, if you remember, with the law enforcement personnel files. They had to file motions, state objected, motion to compel, have a hearing. Court ended up saying you have to turn it over, and then it took another few days to get that done. Grand jury stuff, defense wanted more, state wanted to give them less, or there was some confusion at least. Hearing, we end up figuring out what they get. They get it a number of days later. And I've already seen people on Twitter say, oh, Ann Taylor's going to say, oh, you're stomping on my client's right to a speedy trial. Well, that's the risk you run in the state as you object to things and really fight to keep the defense from getting things that they believe are discoverable. So all of that is important context when we try to figure out why the defense files an affidavit like this. And it is to try and convince the judge, not that the DNA evidence is wrong, not that the DNA shows it's somebody else than Brian Kohberger, not to show it's touch DNA, which is unreliable. They are not commenting on the evidence itself. What they're saying is we need it because it could be important to our case. And if it could reasonably lead to discoverable material, they have to turn that over. And it could reasonably turn into something that could be evidence for the defense. Now, how so? Lawyers can make that argument. They can try to explain that to a judge. And one of the ways we get to do that is by using expert testimony where they can actually explain, here is how we get through whatever your state's bar is for expert testimony and what they say we need this information for, the experiences they've had in other cases as to how this exact information became very relevant and a big part of the case, either at trial or for some kind of motion to dismiss or motion to suppress. It could be really important. All right, let's take a look at it. And again, this is an affidavit in support of their motion to compel. And it is of Leah Larkin. Leah is an adult over the age of 18 and has personal knowledge of the facts set forth in this affidavit. She's been engaged as an expert in the above titled matter since July 27th of 2023. So, and again, all this stuff is kind of important. I just think it's interesting for us to talk about, right? Doesn't prove anything, but to me, if I'm the judge looking at this case, trying to determine if somebody is delaying the case, somebody's taking too much time, somebody may be affecting the speedy trial of this case, the fact that they hired this expert on July 27th and on August 9th, they already have her affidavit is moving pretty quick. She had to look through the case. They had to talk through the issues. She had to prepare the affidavit. Moving pretty quick. Doesn't seem like they're dragging their feet. I am a genetic genealogist, having practiced genetic genealogy since 2014. It's interesting. That's not the longest time in the world, right? But 9 years is a long time. Just usually the experts you see have been doing it for 30 years or whatever. My educational background is a bachelor's degree in biology and a PhD in botany. My curriculum vitae is attached. That's her resume. As a genetic genealogist, I have a clear understanding of how genetic genealogy works. I have developed tools that are in widespread use by genealogy practitioners. Okay. Just briefly saying she's an expert. You can listen to me, Judge. Genetic genealogy is best described as the use of DNA to evaluate biological relationships. There are 3 categories of genealogical DNA: Y chromosome DNA, mitochondrial DNA, and autosomal DNA. A genetic genealogist integrates information from these DNA tests with genealogical documentation to reveal or corroborate relationships. These are some of the parts where it's like, okay, I'll take your word for it, which is not as important as I know what I'm talking about. I study this stuff. Let me give you a brief background so I can explain why the evidence, or I should say discovery, the defense is asking for should be turned over. How can it become important? How can it become relevant? That's important. Genetic genealogy primarily uses autosomal DNA tests that were originally designed for biomedical research. Since 23andMe brought their health tests to the consumer market in late 2007, Family Tree DNA, Ancestry DNA, MyHeritage, and a handful of smaller companies have launched their own genetic genealogy projects. These companies all provide genealogy tools to their customers on their websites and also produce a raw DNA data file that the customer can download. The raw data file contains the genetic profile for that customer. This genetic profile is not the same as an STR profile that is commonly uploaded into CODIS in a forensic DNA analysis. Most of the human genome is identical across all people. Only DNA positions that vary between individuals are useful for genealogy. These variable positions are called single nucleotide polymorphisms, SNP, pronounced SNP. The direct-to-consumer genealogy companies use a type of test called a microarray that samples roughly 600,000 of these DNA SNPs. Unlike the STR markers used for matching in CODIS, SNPs can convey information about medical and physical traits as well as biological relationships to close and distant cousins. A microarray SNP profile is sometimes called a kit. Once the lab test is complete, the genealogy company compares the new kit to those already in the database, looking for long stretches of SNPs that are compatible. The company then presents these matches in a list, sorted by the amount of shared DNA measured in centimorgans. I'm going to be screwing up lots of these words, just FYI. And just so you know, the judge is a lot closer to my level of expertise with genealogy than he is Leah Larkin. Is that her name? Than Leah Larkin's, right? So some of this is going to go over his head like it's going over mine, like it's going over, I'm sure some of you have experience in this, which I can understand as well. So you may get it better than me, but not every word in this is as important as others, I should say. Some words are not as important as others. Standard DNA microarray requires approximately 200 ng of quality DNA. That quality and quantity is often not available from crime scenes or degraded human remains. Instead, specialized laboratories can generate a SNP profile through a more complex process. First, they attempt to sequence the entire genome using next-generation sequencing technology. This technology works a bit like skimming while reading a document. Interesting. On the first pass, NGS technology will not capture all of the data, and it may make mistakes. NGS involves repeated passes, called coverage, to get more accurate results. For human genome sequences, 30x to 50x coverage is recommended. Once the NGS file is obtained, it must be manipulated through bioinformatics to make it compatible with the genealogy databases. The extra data must be stripped out to just the SNPs that the genealogy companies test, and missing or ambiguous data must be inferred using statistical methods. The kit is then uploaded to a genealogy database and evaluated. A poor quality kit might have too few matches, or it might have phantom matches that are not real measures of relationship. Often, the bioinformatics step must be repeated. This trial and error process can take several tries to produce a kit that works well in a genealogy database. So that's the first spot right there, where we just look at the explanation that this test may have to be done multiple times. It can have incorrect matches. It can have phantom things in there that can throw off the test results. So we're working towards why we need to see the raw data, why we need to see how they perform the test. Did they perform it multiple times? Were there phantom issues in there? Was there wrong DNA in there, wrong matches, wrong SNPs, whatever you want to call it? Did they get any other suspects potentially, and they categorized them as incorrect? Again, trying to work towards why the defense should get this information, and their experts like Leah Larkin should be able to look at it. That's the purpose of this affidavit. Only GED match, family tree DNA, and some smaller entities allow crime scene and human remains samples to be uploaded. The terms of service at Ancestry DNA, 23andMe, and MyHeritage prohibit forensic investigative genetic genealogy in their databases. However, in the absence of effective oversight, forensic genetic genealogists are on an honor system to obey the terms of service and the Department of Justice interim policy on forensic genetic genealogy. So here's where we can get a little story time. We had a case in federal court. It was my dad's case. I was clerking, I think, during law school while the case was going on. And there was some cell phone data that was being gathered by the FBI and dealt with by the FBI. And they tried the case once, lost it, appealed it based on, they used the wrong verbiage in the charging document, lost the trial a second time, appealed it, and won and got the case thrown out by the judge after convicting a criminal defendant twice, because she found basically his rights were so trampled on by the FBI. She reprimanded the FBI on the record, basically called him a liar because of how he manipulated the honor system in determining things forensically, technologically, this was dealing with computers. And he violated that and violated the trust of the public, basically. And this is why we have these issues. So that is one of the things I think the defense could potentially be looking for. Did they use one of the sites that you are categorically not allowed to use, violating their terms of policy or their terms of service? And if they did, that could potentially make some of the DNA that was gathered and the tree that was collected and the connecting to Brian Kohberger fruit of the poisonous tree. And that's where it can become part of a motion to suppress, or even post-trial measures like on an appeal, if they can prove law enforcement did circumvent this system and break the honor system. Because that's pretty much what it is, at least according to this expert. Okay? At least according to this expert. And again, none of this is me saying Brian Kohberger didn't do this. I don't know if he did this. He is innocent until proven guilty. We are just looking at this document, seeing what this expert's saying, and trying to determine the different ways the defense could possibly use it. Each of the genealogy databases compares the user's DNA data to all of the other data files in their database, then presents a list of DNA matches who share meaningful amounts of DNA. The match list includes the match's name or alias, how much DNA they share in centimorgans, and occasionally a link to a family tree that the match has voluntarily provided. The genetic genealogy databases are siloed from one another. If you test at Ancestry DNA and your sibling tests at 23andMe, you will not be matched to one another because you are not in the same database. So that's also why it's important. Did they use one of the smaller ones, or did they circumvent and break the honor system and use one of the big ones? And just because they do, I want to make myself clear, just because they did violate the terms of service, I've seen courts say that's not illegal, that's not fruit of the poisonous tree. Maybe they shouldn't have done it, but they did. And this would be too prejudicial to the state, and we're still going to allow it in. I've seen things like that happen before as well. It's up to the judge's discretion if that type of motion is filed, which is, again, sometimes how it becomes an appellate issue if it doesn't get the case thrown out on the trial court level. GED Match is a third-party site that functions as a genetic genealogy commons. A user can upload their raw DNA data file from their testing company and find matches to people who uploaded to GED Match from different companies. Like GED Match, Family Tree DNA, and MyHeritage also allow uploads of raw data files. Ancestry DNA and 23andMe do not. Broadly speaking, the more DNA two people share, the more so wherever I got this document from, that Idaho court's docket, there's something transposed over here, so we can't read the whole thing. But two people share, the more closely they're related. The correlation is not perfect. Okay, never mind. It just moved the paragraph. Any given centimorgan amount can represent more than one possible relationship. Again, now we're getting into the different ways this could have pointed depending on what the family tree looks like. I think that's a less valuable argument, probably. I don't think law enforcement just did this wrong. Did they break the honor system? Possibly. The testing company suggests probable relationships, but experienced genetic genealogists typically use the online shared CM tool shown at right for a hypothetical match of 200 CM. Oh, just kidding. This is something that she put in here as part of her affidavit. To see the mathematical probabilities of different relationships for a given centigram amount, note that there are nearly 20 possible relationships listed for a match of 200 CM, which is considered a fairly close match. I cannot read that exhibit that she put in there. Adoptees have used genetic genealogy DNA tests to identify their biological families for roughly 15 years now. The same methods used for people with unknown parentage can be used to identify forensic samples from a crime scene or unidentified human remains. Unlike standard forensic STR tests, which are used to identify individuals, genetic genealogy tests identify possible relatives. First, the genealogists attempt to build family trees for the DNA match of the person of interest, starting with the closest matches. Relatively few users at GED Match and Family Tree DNA post their pedigrees there, so the genealogist must build trees for them. Just where it starts to get interesting. We attempt to identify the match using their screen name and email address. Then we search public records, social media, obituaries, news articles, and genealogy websites to build out their tree through their parents, grandparents, and so on. Most genetic genealogists build those so-called research trees at Ancestry.com. The goal of building trees is to figure out how two or more matches are related to one another. For example, if the person of interest matches two people who share a great-grandparent couple, making them second cousins to one another, the genealogist now knows which branch of their tree is relevant to the search. The person of interest could be descended from that couple, or the connection could be one or more generations further back through either the husband or the wife in that couple. Once several of the DNA matches have been connected to one another, the genealogist must figure out how the person of interest fits into the tree of those matches. We use age, sex, geographical location, and other circumstantial evidence along with the DNA-based relationship predictions. A statistical tool called What Are the Odds can analyze multiple DNA matches together to evaluate where the person of interest best fits in to the tree based on the amounts of shared DNA. What are the odds is not intended to give a definitive answer. Rather, it points out the genealogist toward the most likely branches in the tree for further research. The tool is also not appropriate for all circumstances. For example, it is not intended for populations that married within themselves, for double cousins, or when most of the matches are below 40 cm. We won't talk about what states that might apply to more than others. The genealogists need to do this for both the maternal and paternal sides of a person's interest pedigree. Often, this involves building dozens of trees and performing several what are the odds analysis. We are looking for instances where a descendant in one DNA family tree married a descendant in another DNA family tree, because those unions point to where the person of interest might fit into the tree. Often, the best we can do with the existing DNA matches is to focus on a set of cousins as candidates. Then, more DNA testing is required. Okay. What she's trying to do here, I think, is explain how the information they get is imperfect. It goes through a lot of different steps where something could go wrong in those steps and the margins of error is small, and it could be somebody that's related to them 3 generations back by marriage. And I think the point of this is how they would attack this way of gathering DNA evidence. Now, if I was the state and if I'm the judge thinking about this, do they need this additional data and information that they're trying to seek in discovery? Do they need it to make these arguments? Because to me, it sounds like through cross-examination, the defense attorneys could say, this is how you did it, right? Through what are the odds, through 23andMe, whatever. Then you bring up your expert and they can still explain how they believe that is a flawed way of doing business, how there are all these different spots and error can be made. So this to me might not be as strong as it sounds as far as an argument goes as to why the state should produce this discovery. Okay. The process can vary in complexity depending on the individual starting point. In doing this type of research, the genetic genealogist will generate numerous documents to ensure an adequate paper trail. Now, this is where it goes to, they should have something to provide us. This paper trail can include the list of DNA matches, the research tree with genealogical documentation, public record searches of members of the DNA family, correspondence with DNA matches, descendant diagrams showing how the DNA matches are related to one another, and what are the odds analysis. This documentation is necessary and important for the following reasons. DNA matches, and here we go. So that documentation is necessary and important. So if they don't have it, that seems like something the defense is going to highlight. And if they do have it, this is why we need it, Judge. DNA matches sometimes hide their profiles. An error in the tree can mislead the genealogist. And the descendant diagrams are what are the odds analysis are usually updated repeatedly during the search. As a genetic genealogist, I have learned about the power and the privacy implications of genetic genealogy. The tests themselves were designed to reveal biomedical information and can also reveal family secrets about the tester. In many cases, private information can be inferred about the DNA relatives of the tester as well. For these reasons, leaders in the genetic genealogy community develop standards that emphasize consent and privacy. I am aware of the Department of Justice interim policy to limit when forensic genetic genealogy can be used and which databases are accessible to law enforcement. It is possible for the databases to be utilized in a way that circumvents these core principles. Notably, I am aware of, so here we go. Now she's going to point to real life cases and instances where this has absolutely been relevant and important and material in cases. First, a case in which the chain of custody failed and the wrong SNP profile was sent to the wrong client. Investigative genetic genealogists uploading SNP profiles to a forbidden database in violation of the company's terms of service, and the Department of Justice and her policy. She actually knows of cases where that has happened. Forensic genetic genealogy being used for a case that did not meet the Department of Justice threshold. Investigative genetic genealogists using security loopholes to see DNA kits who are opted out of forensic matching at GED match and family tree DNA. Again, circumventing the honor system, basically. We've seen this happen in cases of our own. A case in which a SNP profile was performed on an innocent woman, a potential Fourth Amendment violation of her right to privacy, and uploaded to GED match without her knowledge and consent. And here we go. Here's the final kicker here of what the defense needs the judge to understand, why they need this discovery. They have an expert even saying it. Having access to the DNA and methods used to identify someone will provide answers to why is it material, why is it potentially relevant, and why is it definitely discoverable. Compliance with the Department of Justice policies, how a DNA sample was handled from the time of collection through its forensic genetic genealogy testing, the process of the SNP creation, the use of the SNP profile, the use or lack thereof of loopholes and violations of terms of service to the various genetic genealogy databases. And that could lead us to motions to dismiss, motions to suppress, motions for sanctions, all sorts of things, if any or all of these 5 issues or problems happened. And I think she did a good enough job of explaining why these documents will help answer these questions. All right. let's get to some of your questions. So if you have questions, throw them in the chat now. I'll leave this up on the screen, kind of the final 2 points, I think, which are probably the 2 most important points. And let's ask, or I should say, answer some questions. Christina Rain, so ready to hear about this genealogy info unpacked. Let's go. Well, I hope I didn't disappoint you by telling you whether or not I think this stuff is legit that she's saying as far as how it works and how it's used and where it can go wrong. But I think she's presented enough in this affidavit to say the state should probably turn this stuff over. And if it happens after all of this fighting, all of these motions, having to hire experts, not being able to respond with this affidavit quicker because they did have to hire an expert, the expert to do the work and provide this affidavit, that I think we're going to have some more complaints by Ann Taylor that the state is trying to manipulate the system to violate Brian Kohberger's Fifth Amendment right. Waiting for Peter's reaction to page 6. Is this page 6? So I don't know what reaction you were expecting, but I'm not very surprised. It's not just in DNA testing. It's in just about all technology, anything that's newer aged, anything that you think as law enforcement is, you either convince yourself you've got the right person, so you're not doing anything wrong, you're not breaking any laws, but you're just not doing things the way you should, that you know you should. Nicole, I find it hard to believe the prosecution would use DNA they obtained illegally. Am I being naive? So, Nicole, I like to hope that that's true too. And I think it's very well may be true. And maybe when they produce all this stuff, the defense finds nothing. Maybe the defense finds something that they think is important and it ends up being nothing. Maybe it ends up being something. Here's what I will say. I know for a fact things like this have been done by law enforcement in the future. That in and of itself does not mean it's happening here. I think that's important, that we don't paint with too broad of a brush. But because it can happen, I don't see the harm in turning it over and letting the defense look at it. Because the next bar, getting it into trial, making it admissible evidence, is very different than what makes something discoverable. Tina, thank you so much for the super sticker. And welcome to all the new members that have joined us during today's video. A Tribute for You, LLC. Welcome. Thought I saw one more. It may have popped off the screen. Barbara G. So is this expert insinuating that they didn't follow the honor system? She's saying, Judge, here's the way it goes. If they didn't follow the honor system, that is a violation, and that could render the evidence fruit of the poisonous tree. That could render the probable cause affidavit. That could be issues there. I know they said that they believe they have probable cause without this DNA evidence, but could be issues there. And the only way we will know if they violated the honor system to create those major and material issues in this case is if we get the data we're asking for. That's the main question. Not did they violate the honor system? Not is this evidence going to get thrown out? That's not what we're answering here. All we're answering is, do they need this raw data for something in this case? Is it discoverable? Allison, any idea what he could possibly want to talk to the judge about? Maybe info about a police officer. So I think you're referencing the alibi that they want to have the ex parte conversation. I think it's more like, Judge, here are a couple different things we're considering based on how the evidence presents itself. He was out driving. We don't know if we can prove he was at this location or that location. We're trying to get that camera evidence. We're trying to get his key card. We're trying to get a witness statement. I don't know what it is, but I think it's kind of explaining something like that and explaining why to the judge they don't have all of the information for the alibi yet. And of course, they're going to say, plus the state's not giving us the discovery we're asking for. John, will GED match hold up in court as a certified source? Seems like a not qualified source. I don't know. Thoughts? I don't think GED match is going to be on trial here. I think it's just going to be the way law enforcement handled this and got the DNA profile and whatever aspect of it they're going to use and present at trial. And I think law enforcement's expertise would be enough to get that in, assuming no funny business was going on in the background. Azam, I feel like I'm in a biology class. I have to leave. My class begins at 9:30 a.m. I will join the rewatch crew this afternoon. Thanks, Peter. Thank you, Azam. Thank you for joining us early in the morning, late at night. Doesn't matter the time, you're here. Rubber Toe. I can't see how the prosecution won't be forced to give them this discovery. They aren't even asking to make it out of play. Yeah, I would think they're going to as well. Peter, how do you think this is going to play out? Ashley, I think the state is going to have to turn over this information. I hope they do, because if he is the guy and they do go convict him, I don't want this to be an issue we look at later. And, because they got it from the wrong website and should have been able to use it, and it's probably going to be a big deal at trial. There's no way they're going to be able to get away with, oh, we didn't really need the DNA if they use it at trial, because I think it's potentially the most important piece of evidence that they have in the case. Bailey, is it just me or does this case seem strange? Is it normal, or from your experience, is this case different than most? Like maybe he did it knowing how to get off. So there are cases like this, they do exist, but the publicity and the demand of speedy trial do make this case unique. A case with this much publicity going to trial within 6 months would be very unusual. We had it in Murdoch, I think, pretty close to this. But again, very unusual in my experience. A lot of cases will waive speedy trial to make sure we can get everything we need to get done and prepare our defense appropriately. So that's why it's unusual in my experience as a private lawyer. Very different. Public defenders may have a different experience with that, but it does seem, I don't know if strange is the right word, but there's a lot of things going on, and it's a circumstantial case, and the defense has a lot of ways to poke holes. But I do think right now the state has a very clean story they can tell if a jury believes it. I think they have enough to convict him, but I think the defense is going to have a lot more to work with than your average case. So this is one that is interesting to watch more than it is strange. Deborah, how does that information make her client not guilty? That's not what we're trying to do here. That's what I try to kind of set up at the top. So I'm glad you asked this question. This affidavit is not going to prove that Bryan Kohberger is not guilty. This affidavit is not going to prove that that is not Bryan Kohberger's DNA. That's not at all what the purpose of this affidavit is. Purpose of this affidavit is to tell the judge, we need those documents we keep asking for that they won't give us. And this is why. So what is the info they are wanting but don't have? I think it's the raw data. We read the motion to compel before. I can't remember exactly what the IgG stuff is that they're asking for, but it's basically how they get to the DNA information they're going to use. They say we just have to use the end results, basically, not all the work we did in the middle. We don't have to show our work. John, shout out to Melanie C. New baby. See you in the next video, friend. We have added another viewer to the Lawyer You Know team. Melanie C's baby Uhtred. Welcome to the squad. Pumped to have you. Praying for a happy and healthy baby and mom, of course. So thank you for sharing that with us. She was watching while at the hospital waiting to give birth earlier today. It sounds like, I don't know if she said in the chat that the baby came or is coming soon, but that's going to be awesome to celebrate together with. Katie, this case is starting to hurt my head. Any case that has DNA stuff can get a little wonky like this. Sometimes I feel like cell phone data can get like that. And it's really hard. And the state has the burden to make it useful, make it make sense. That's on the state. CH, question. If the IgG tip became fruit of the poisonous tree, does all that comes from that also get thrown out, i.e. the PCA and arrest warrant? So I thought I remember that they said they were not relying on the DNA for the probable cause. I could be wrong. I think it would just be the DNA results and things like that. It wouldn't be the car data. It wouldn't be the bushy eyebrows, witness testimony. All of that stuff would still be coming in. But we'd have to see what it touches, right? That's what's always hard too, is from where we're sitting, we don't necessarily know what it touches. Denna, thank you for the super sticker. All right. So another thing that I did want to talk about at the end of today's video, it's a night one. We're kind of winding it down. We might answer another couple questions if John wants to start some. But EJ, who is a cornerstone, a stalwart, always in our chats, has been battling some health issues, and she shared with me, or her family shared with me, that she passed away. And I just wanted to give her a shout out again and remember her, and anybody in her family is coming and watching us and hanging out with us in here, that we love EJ. We will miss her so much, her contribution. She sent me some books that she wrote that I can't wait to read, that I have in my office. She was a light. She was so much fun. She'll be remembered for that in this chat. And will always bring smiles and happiness to our faces as we remember what a good time she was with us, as I'm sure all of the memories her friends and family have as well. So I did want to mention that. And we're still praying for comfort for her family. And it's always hard to deal with loss, but she will always be remembered amazingly here in this chat. Yes. And thank you for all of the comments for EJ. Okay. That's always tough. CC, thank you for the super sticker. Jessa Twin. I'm confused. Why does he need to answer any questions about an alibi? I thought you could remain silent. He does. He does not need to speak, but they do need to say he was in his car or whatever, provide where he was. It does not have to be through his statements. And if you listen back to the video where we go through his alibi the second time, they talk about how he still has the right to remain silent. Nicole, did they collect DNA after arrest? If so, this point is not moot. So it's how they connected his dad's DNA to his from the trash, I believe, and how they connected it all together to get to him, right? And then what is the fruit of that poisonous tree? It is possible that a lot of that stuff gets suppressed, or maybe it's not even going to be material like the state says. Maybe that's not even going to come to trial. And maybe the fact that they arrest him, they get the DNA post-arrest and they connect that to the touch DNA, that the touch DNA still comes in. That's possible. That's a possible outcome. But then we have to go back and did the judge or anybody consider the DNA in the arrest, in the probable cause? Even though they make that little asterisk that we have probable cause even without this. Is this the reason why? Did they know that they violated the honor system? A lot of questions we don't know. And we don't really know what the fruit of the poisonous tree would touch if something was suppressed dealing with this. And that's why the defense needs the information to see what they're going to even argue. Can Brian take the stand if he admitted guilt to his defense? Yes, and this is a question we answer so often. You can, as a defense attorney, you can't put your client up there, ask them questions knowing that they're lying, committing fraud on the court. If you think they're going to lie or say they want to lie, there's a lot of procedure you have to go through, maybe even notifying the court, potentially, depending on how bad it gets, or you just sit down and say, defendant, go ahead and tell your story. But you can still present a defense even if they admit that they are guilty by presenting the fact that maybe the state didn't do their job. And again, you can put the defendant up there. You can't ask him questions eliciting a lie. If he lies during the state attorney's cross-examination, again, depending on what state and the rules you have of ethics there, you might have to put the court on notice. You might have to put the state on notice, so it can get really, really fishy. So usually you don't want to do that, but there are still defenses that you can present. Stephanie, am I the only one who can't get Lizzo? A DNA test turns out. I don't know that. I don't know that one, Stephanie. Everybody was making fun of me in the last video for saying Lizzo was R&B, like Meghan Trainor and somebody else. And they're like, Meghan Trainor's not R&B either. I'm like, I know. I guess like R&B is like just Boyz II Men is the only thing I can think of for R&B. That's pop music. I was corrected. So thank you for that, everybody. CMDA, thanks for the super sticker. And Johanna Morgan. Miraculous Hufflepuff. Just came from watching Murdoch playlist. It was right in my area, and I'm glad to see your take on it. Do you think the judge is going to reprimand the state for dragging their feet seemingly? It's such a balance because you have to be able to fight for what you don't think is admissible and making it a fair trial. We just recorded the fair trial rights of a prosecutor that's going to drop on Monday. The video for the rights of the defendant is going to drop Friday. But it's really interesting what a prosecutor's rights are as well. They have a right to a fair trial as well. They have a right to fight. They have a right to say, no, you can't have that. We don't think it's discoverable, and have the judge make a decision without being in fear of saying, oh, that's too much of a delay. We're violating a defendant's speedy trial rights. Because you can't make that argument every time the prosecutor disagrees with you. They're allowed to read the rules of evidence and have an opinion as well. And that's the point of the judge, is to make this call. Now, that's not going to stop the defense attorney from saying, oh, look, they're violating our speedy trial rights. And it may be true. I don't know. Maybe they have more information, like emails back and forth saying, you could have had this to us 2 weeks ago and you didn't. And every 2-week delay is very important in this situation. Hi, Castles. Hello, and sending love from Ireland. It's 2:30 a.m. Glad I'm working the night shift to catch your live for once. One day, I'm going to get to Ireland and I'm going to play some golf. One day. Day is not today. Koala T, thank you for the super sticker. And CMDA, thank you as well. All right. That's all I've got for this late night live. I appreciate all 4,000 of you that decided to jump on here and hang out with me tonight. I'm going to try to get in the chat tomorrow. I probably won't be able to, but check out that video on Alexi Treviso. Can you all do me a favor? Hit that like button before you leave. All 4,000 of you. Let's get 4,000 likes before you sign off, before the video ends. And if you want to know what I do for a living, I am a real lawyer. I know people can't believe it, especially these late night lives. Guy in a man bun wearing a Top Gun shirt couldn't possibly really be a lawyer. I am. If you want to hear a little bit more about it, that's what our outro is about. If not, thank you so much for joining me. It was fun to hang with you. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.